We have a group of ethical rules that specifically relate to lawyer conduct in litigation or similar types of advocacy. These rules address how lawyers interact specifically with judges and jurors and witnesses or the opposing party in litigation. And these are the rules that start with 3.1 to 3.9. Rule 3.1 begins, "A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein, unless there is a basis in law and fact for doing so that is not frivolous," which includes a good faith extension for or modification or reversal of existing law. Now, Rule 3.1 continues, "A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established." So before we go into too much detail with the comments, here are some key points to note from this rule so far before we move on. First, this rule applies not only to filing lawsuits themselves, but also to an individual argument or to claims and defenses, which it calls contentions, within an otherwise proper case. So most law students have heard of frivolous or vexatious litigation, but notice here that the rule covers more than just bringing bogus lawsuits. It also prohibits raising a frivolous defense or to make frivolous claims or arguments within an otherwise legitimate case. So you could have a valid case or position in the litigation overall, but still violate this rule by raising that one extra argument that is simply unsupportable. Second, before we move on, note that this rule, how it defines the problem. You must have a non-frivolous basis in law or a legal argument plus non-frivolous arguments in fact. So if you have might otherwise be a valid legal claim in another case, but you have no factual support whatsoever, you violate this rule. And the same is true if you have lots of evidence and hard facts, but your legal argument is ridiculous. Third, note that the rule allows lawyers to argue against existing precedent as long as they are making a good faith argument that precedent should be overturned, like the plaintiffs did in Brown v. Board of Education or in Lawrence v. Texas. In other words, you won't be subject to discipline if you're making a good faith argument to change the law in some way. Let's say to overturn it, or maybe to extend a rule further than it's ever been applied before, or maybe to narrow a rule more than it has been before. But you can't just ignore statutes or controlling case precedent that happen to be bad for your side, or make up fake statutes or fake cases. So arguing to overturn established law is not necessarily frivolous. Also, moving on, a weak criminal defense is actually okay under this rule. In other words, it will never be frivolous to serve as defense counsel for a criminal defendant, even if they're obviously guilty. Sometimes criminals are caught in the act, or they fall for an undercover sting operation, so their crime is actually on video. Or sometimes before they call their lawyer, they already confess to the crime, or there's just overwhelming evidence that's irrefutable. But because we're so concerned about due process in criminal cases, it's still okay for the lawyer to make the prosecutor do their job, to prove all the elements, even if a guilty verdict seems like a foregone conclusion. And a lawyer will not be subject to discipline for doing that. Now, if you're arguing that your client is a sovereign citizen and is not subject to the laws of the jurisdiction where they live or the jurisdiction of the court, that's a ridiculous legal argument, and a competent lawyer could not make that argument in good faith. And the same would be true with arguing some other sort of crackpot theory, like that the existence of police is unconstitutional. But you can make the prosecutor go to trial and prove the state's case beyond a reasonable doubt, even if it seems certain that your client will be convicted. Now let's talk about some of the points made in the ABA's comment to this rule that you might see show up as test questions. Comment 2 is about whether discovery is really needed. So it says, filing a claim or defense for a client is not frivolous merely because the facts have not first been fully substantiated, or because the lawyer expects to develop vital evidence only by discovery. So in other words, it's not frivolous to bring a case without having all the proof that you would need to win up front, as long as you honestly expect to get such evidence during the discovery phase before trial. So if you have good reasons to believe that such evidence exists and it will come out in discovery, then it's permissible to bring the case. On the other hand, comment 2 says that lawyers do have a duty to inform themselves about the facts of their clients' cases and the applicable law. So you have to determine whether there are good faith arguments in support of the client's positions before you bring it in court. Now, keep in mind that loser lawsuits are actually okay. That is, a claim or defense is not frivolous just because it's a long shot case. So you can technically bring a case that's 90% likely to lose. The rule says no basis in law or fact that is not frivolous. So a lawsuit or action is not frivolous just because the lawyer believes that the client's position ultimately will not prevail. Long shot lawsuits are permissible if the lawyer can make some good faith legal arguments and offer some supporting facts. Make sure, though, that you explain to the client, of course, that the case is a long shot and not a sure win so that they have realistic expectations going into it. Frivolous means no basis at all. It is frivolous, though, if you cannot make some good faith argument on the merits of the action taken, or support it with a good faith argument for the extension, modification, or reversal of existing law. Now, one final point in the comments about criminal cases, which are different. Defendants in criminal cases, remember, have some constitutional rights that limit Rule 3.1. So there are more procedural protections at trial available to criminal defendants than there are to civil defendants, like, let's say, the defendant in a tort suit. Thus, they can make some claims and contentions that Rule 3.1 would otherwise prohibit in a regular civil matter. And that concludes our brief overview and introduction to Rule 3.1.